Hello, good evening, everybody.
Good evening.
Good evening, good evening, Miss Juliana. Thank you so much for joining us today. Thank you to our mentors. I hope that they are here already. Thank you so much. My name is Mayna Basiwili, and I'll be your moderator for this session. This is the Jiipcc Mentorship and Internship Program, the third quarter. This is the third quarter for the year, and this is one of the sessions when we'll be having the mentors, the mentees rather, do their presentations, and then we'll have our mentors comment and answer questions to help us. Please, Mr. Hussein, I can't see.
What do you want me to share?
Okay, sir. I will go on ahead to the announcements. I'll go on with the announcements while waiting for that. Okay, so registration for the fourth quarter of JIIPCC mentorship session is ongoing. You can find the link on the Jiipcc page, and then there's also be reminded that there's 30 minutes of private mentorship with mentors available for present mentees. And throughout this session, it's encouraged that you should put your videos on, and we are streaming live. Please edit your names in the name section. This goes to the mentees, please. This make sure you edit your name in the name section of your Zoom account, so that your attendance can be taken. Your full name, please. And then there's also ongoing registration for the Jiipcc end of year party. The date for the end of year party is Saturday, and it holds in Abuja. So now I'll go.
Lagos. So you're also holding it in Lagos too.
Okay.
Yes.
No. So it will hold in Abuja and in Lagos. So if you are in any of those places, or you can easily get there, you have the intentions to travel down there, please register. To be nice to see all of our faces again, or basically physically, to be nice to have a physical meeting and link up. Okay. For each group is to present for 8 stick notes, and let's try and stick to time. Before we go ahead to the presentations, I would like to read out to introduce basically our mentors for today. Our first mentor is, I hope that I pronounced that right. Okay. Mr. Amobi Ezeaku, and he is passionate about the advancement of football in Africa, especially with respect to laws governing the game, administration, safety and security, as well as a transfer matching system. We are glad to have you on this session, sir. We hope that you're here.
Thank you so much. I'm glad to be here, and I hope we all would have an exciting evening.
Yes, sir. Welcome once again, sir. Okay, the next mentor for today's session is Mr. Max Ikongbe. Mr. Max Ikongbe is the founder or principal of Everlaw Associates. He works extensively in the fields of arbitration, ICT, technology law, and intellectual property. Mr. Max is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patents Registry and has conducted IP registration business there since 2010. You're welcome, Mr. Max.
Thank you very much. It's a pleasure to be here as always. Thank you.
Thank you, sir. Okay, so now we'll go straight into the presentation. We'll go straight into the presentations. Please remember that each group has 8 minutes. Please remember that each group has 8 minutes to do the presentation. Okay, please, the presenter for group 1, are you available?
Yes.
Okay, please.
Okay, can we see my screen?
Yes, we can.
Okay, thank you. Okay, good evening, everyone. My name is Precious Siri, representative of Group 1. I'll be taking us through intellectual property in sports, particularly centered on protection of inventions and brands in sports. Now, to start with, intellectual property ranges from trademarks, copyrights, industrial designs, as well as the legal protection that they offer to secure the economic value of sports. This in turn stimulates growth in the sports industry, as well as development in the sports industry. Now, sports shows intellectual property in action, as patents encourage technological advances that result in better sporting equipment. Trademarks, brands, and designs in turn contribute to the distinct identity of events, teams, and their gear, while copyright-related rights generate the revenues needed for broadcasters to invest in the costly undertaking of broadcasting events to fans all over the world. Now, I'll be starting with industrial designs. Now, the influence of designs in the world of sports is something that is quite phenomenal. Where image and aesthetics are involved, of course, it is only natural that the designs will be involved as well. Now, designs contribute to the distinct identity of events, teams, and their gear. Design rights can also protect the designs of golf courses, apparel, training kits, and so much more. They can also be of particular relevance for organizers or sports events that can benefit from registering their 2D or 3D shapes of certain products associated with their events, like mascots, trophies, and the likes. Now, this is particularly important because shapes help to play an essential role in making a product more attractive and desirable, which then adds commercial value to such products and makes it more marketable. And this brings more money to the producer. Now, registering designs is not something that can be underemphasized, as it helps companies to defend themselves against imitators or counterfeiters. However, in most countries, Nigeria inclusive, an industrial design must be registered in order to be protected under the various industrial design laws. So this makes it geographical in nature, and hence protection is only given in only the country that the design is registered. However, an easy and cost-effective solution to this is making use of the WIPO, provides protection across multiple countries. An example of this is the Olympic Games and the UEFA Champions League logo, which you can clearly see on the slide here, which is said to be the most recognizable logo in the world, and it generates billions of dollars and millions of fans. Now, moving on to trademarks. Trademarks are vital intellectual assets in the sports industry, as they help to distinguish goods and services of sporting industries or sporting organizations rather, or brands from other sporting organizations or brands. Now, this may include the players' names, drawings, or symbols, or even a combination of all these things that I've mentioned. Trademarks in the sports industry serve as identifiers or indicators by drawing the attention of consumers to the origin of that particular product or services. That is to say that it makes them want to buy such products or services. Now, examples of trademarks in the sports industry include Liverpool Football Club, "You Will Never Walk Alone," Manchester United slogan, "Glory, Glory, Manchester United, GGMU." By the way, shout out to any Manchester United fan in the house. Hopefully you all are not still paying by the 4 that they gave you last week. Now, other examples of trademarks include Nike, Adidas, and Puma's logo used for sporting clothing. Now, a lot of sports celebrities generate large earnings from their personal brands as elite athletes, as well as from several endorsements that they engage with other brands. And the goodwill which they get from all this is due to the fact that they register their trademarks or their brand names. Now, an example of a business that lost revenue due to its non-registration of trademark is the Barcelona Football Club. Now, this football club lost a major domain name due to a dispute case that involved a Bayern Munich fan. And the fan had registered a domain name FCB email. However, Barcelona Club, upon litigation, was unable to substantiate their claims of such domain ownership, even though it was a clear case of cyber squatting. And this led to them losing commercial value, as they were not able to generate commercial value from their trade name. Moving on to patents. Patent in the sports industry covers various forms of innovation, creations, and inventions that relate to the sports industry. Now, one notable patented technology is Hawkeye Innovations Video Assistant Referee, I'll call it VAR technology, popularly used as a referee's assistant in football matches. And it is used to review clear and controversial errors in the course of a football game. This patent enables the patentee to enjoy commercial benefits from his invention by entering into licensing agreements with various sports organizations, for instance, FIFA, in different countries across the world. Now, an example of patents in sports. It is difficult to think of patents without imagining the use of equipment, especially the use of balls. In various sports that we have nowadays, most of them, they involve one ball or the other. We have football, we have basketball, we have volleyball, but we'll be particularly centering on basketball today. Now, basketball in the olden days, before we knew before basketball became what it is right now, it was played with the soccer ball. However, efforts were made to produce balls that will fit the peculiarities of this wonderful sport. So in the year 1929, a man named George L. Pierce invented the basketball that we all know and love today, and was, of course, awarded the first patent for such wonderful innovation. Now, moving on to copyright. Copyright-related rights generate the revenues needed for broadcasters to invest in the costly undertaking of broadcasting sports events to fans all over the world. It protects any artwork and audiovisual creations used to publicize a show. So without copyright, it would be difficult for broadcasters to transmit coverage of their events and to engage fans all over the world. Now, an example or a notable example of this is the broadcast revenue that was generated from the Rio 2016 Olympic Games. Logo is clearly seen on the slide here. And the result of that was $2,868 million US. So that's an example of a person who benefited from registering their copyright. Now, of course, just like every other field, there are several legal issues that can also arise in the sporting industry, including infringement of trademarks, brand abuse, misbranding, or even the use of patented technology without authorization from the owner of the patent. That is why the registration of one's intellectual property is something that cannot be underemphasized, especially in the sporting industry that is fast becoming a billion-dollar entity. In fact, to his credit, the sporting industry is one that accounts for over 3.7% of the aggregate GNP of the 28 European Union states, and also responsible for over 3% of world trade. So conclusively, if intellectual property rights are not effectively managed, the owner of such rights may not be able to effectively maximize the benefits associated with such rights. So I'll be stopping here for today. Thank you all very much for listening.
Thank you so much, Ms. Precious. Thank you. That was a wonderful presentation, actually. And I am so glad I'm not a Manchester fan. Okay. Okay, please, is the presenter for group 2 present, please?
Yes, I'm present and I'm ready.
All right, you can take the floor.
I hope he's not a Man U fan.
All right, everyone. Good evening. Good day. My name is Benjamin Samalu, and I'm presenting on behalf of Group 2. Our topic this week is licensing, merchandising, endorsement, image rights, and sponsorship in sports. To begin with licensing, licensing is an agreement through which the licensee leaves out the rights, the legally protected piece of intellectual property to a licensor. That means that the licensee is one to whom the right to an intellectual property is being leased out, while the person leasing out his right is the licensor. Now, licensing is actually a business, a marketing strategy that is utilized both by small and big businesses because it helps them boost their income and to promote their business. It is worthy of note to state that the holders of the intellectual property rights do not actually transfer the ownership of their intellectual property to the licensee, unlike in an assignment agreement. Now, licensing can actually be following types. One is exclusive license. Exclusive license actually gives autonomy to the licensee over the intellectual property that we use out. That is to say, the licensor cannot use the goods for any other thing. And the second type is non-exclusive license. Non-exclusive license is actually the opposite of exclusive license. That is to say, the licensor is free to exploit the same intellectual property right that he has leased out to the licensee, and he can also lease it out to a third party. Now, moving to the third type of licensing agreement, which is sole license. Now, this type of license is almost similar to the exclusive type of license, in the sense that the licensee has the licensor cannot lease out said intellectual property that has been leased out to another person. However, in this type of licensing, you can use it for his own benefit. Someone is saying he can't hear me. Please, can everyone hear me? Hello, can anyone hear me?
No.
Yes, we can hear
Yeah,
you.
we
Can
can hear
hear
you,
you.
but your volume is quite low.
All right, so let me increase the volume. Hope I'm loud and clear now.
Yes,
Yes.
yes, perfect.
Oh, thank you. So, the rights which can be listed out in a licensing agreement range from patents, copyright, trademark, and right to publicity. So moving on to merchandising. Merchandising is a placement on the market, on the market, fictional characters, real persons, names of sports club, etc., to promote a business. Now, it is a way of promotion by displaying and doing other promotional activities. In the realm of sport, merchandising is actually of various types, but the basic type is character merchandising, which involves the use of a fictional character of a person or the real character of a person to promote a business. Under it, we have the personality merchandising. And under personality merchandising, the unique character or traits or personalities of a sports star is being used to promote a business. Example is using the advert for TomTom, which has been tagged as the candy for the Super Eagles, or the advertisement done by Milo, making it look like all members of Superstar Eagle usually take Milo as their own drink. And another type of character merchandising is image merchandising. Now, this involves the use of fictional characters and associating them with real life celebrities. If you have ever been to a PlayStation shop or a bet shop, you would usually see all those video games. Now, what is there is just a fictional person. It's not Ronaldo or Messi that's playing in that TV. It's just a fictional representation of him, but it is being attributed to the characters of the particular club or the particular star. It is also important to note that this image merchandising is different from fictional merchandising. Now, in fictional merchandising, the character there is not attributed to a real person in sports. And merchandising can take any of the following forms. It could be related to a sport personality in person. It could be related to the team or club, or it could as well be related to an event, to a league or to a tournament in general. Now, moving on to the next part of our presentation, which is endorsement agreement. Now, what does it mean to endorse a person, to endorse a brand in the area of sports? Now, endorsement is a contractual agreement that allows a company to utilize a well-known person to advertise their product or services with that person's permission. Now, they associate their brand with that star by drawing attention of the media. So if today now Messi comes out and says cornflakes is what he takes in his house, cornflakes is what all of his family used to take, there are people that definitely will venture into taking cornflakes because he has done that. And by so doing, he has endorsed the business of the brand of cornflakes. So now, what are the intellectual property rights that can be protected or granted under the merchandising, the licensing, or the endorsement? Now, there's no a clear-cut answer to this, as it all depends on the contractual agreement that has been entered into by the person, by the sports star or the sports club, and then the brand they are seeking to promote. It could be that they could have a fee in payment, they could have salaries, or they could have compensation. While for the brand, their own is to promote sales, to advertise their brand, and to help their business. So moving on, we'll be talking about image rights in sports. We all know image is the painting, the photograph, or a sculpture of a person. Now, how is image rights used in a sport? Now, image rights can be granted by the owner of the image to another person to be used by it. Example is that you see the pictures of basketball stars or football stars on jersey shirt. All these are ways of promoting business using their image rights, which they have granted to the brands that are using them in their business. Now to the last part of our presentation, which is sponsorship in sport. Sponsorship means to sponsor someone or something or an event. If we check history, we will notice that a lot of brands, top brands in the world, are actually competing to sponsor Olympics, to sponsor La Liga, or to sponsor Champions League. Now they do this with the aim that at the cost of this, their sponsorship, they will gain popularity as they will be advertised or they will be merchandised by those clubs, and it will help them to boost their business and to promote their brand. So now to the last part of it, which is the cases. We have the case of Rogers versus Cons, and we have the Nigerian case of Njoku versus Komena. Njoku Komena versus KDTA. Now, for want of time, I won't go into details of this case because they are actually bulky, but they border much on the use of photograph. Now, there are basically two arguments on the use of image rights and in sponsorship and sports. The argument is whether is who owns the copyright to a particular picture. On a general note, we can say that ownership of photograph or videos in the copyright ownership actually belongs to the creator. However, looking at most contractual agreements, we will come to realize that the photographer or the videographer is actually being paid for the work he's doing, and as it is contained in the terms of the agreement, the copyrights will be retained by the person who employed him. So this is our presentation, and in conclusion, I would like to state again that the rights that are being protected and the benefits to be enjoyed from any of these forms of agreement will depend on the kind of contract and the clauses that have been inserted into the contract by both parties. Thank you for listening. This has been our presentation for today. Thank you.
Well, thank you so much, sir, for that presentation. I learned a lot. Actually, it was really detailed. Thank you so much for that. Please, is the presenter for group 3 present? Please, the presenter for group 3. Okay, while we're waiting for the presenter for group 3, please, is the presenter for group 4 present?
Yes, she's
Okay.
present.
Please go ahead. Thank you.
Good afternoon, everyone. My name is Titilola Akinshola, and I'll be presenting for group 4. A minute, please. Can you all see my screen?
Yes, we can.
Okay. All right. So our topic for today is applicable dispute resolution methods in sports. And we'll start from the definition of dispute resolution methods in sports. This includes measures taken to resolve disputes in the world of sports. And we've seen that from our last studies and last classes, we understand that alternative dispute resolutions has always been or has been commended or has been recommended in solving disputes, especially in the world of sports. As Gardiner said here, the sports world is a small one. Everyone seems to know other people. Hello? Is somebody trying to say something?
Oh, carry on. You can hear you. Let's
Okay,
continue.
thank you very much. As I was saying, Gardiner writes that the sports world is a small one. Everyone seems to know the other people. Thirds, relationships and reputations are worth preserving. So the use of ADR, the disputes can be resolved within the family of sport itself. And we can't agree. We agree with Gardiner with what he has said here, that ADR is one of the best measures of resolving disputes in the world of sport. And the usage of ADR in sports can be traced back to the decade of 1980s, in the 1980s, when sport-related disputes increased. And so International Olympic Committee established the Court of Arbitration for Sport. So in 1984, CAS started its operations. The most preferred method of dispute resolution in sports. In India, there are several leagues and tournaments going on every year. There's cricket, badminton, kabaddi, athletics, football, every other sport. And then we understand that instead of going through litigation, instead of going through the rigors of court in, court out, as Gardiner said, to preserve the relationship, to preserve time, and which is one of the most important thing in sports, to preserve time and all those things, it's better to just call everybody to a seat and resolve it. Could be through arbitration, mediation, negotiation, and conciliation. The use of arbitration to resolve disputes arising out of sporting events and participation in regulated sport activities is well established. Arbitration has proven to be an extremely successful method of resolving sports disputes, and as a result, it has gained the favor and confidence of the sporting world. This success has inevitably led to a massive increase in the number of sport arbitration taking place in recent years. So why arbitration? Arbitration is also as formal as litigation, but it's more efficient, it's quicker, it's less expensive, and provides flexibility of process and procedure. You can set your time yourselves, you can pick your own arbitrator, someone well-versed in the field of sports. That's something you might not necessarily get in courts. Though some courts try to appoint people that are versed in different areas of law and or of business, but in sports, especially in arbitration, you have the authority or you have that flexibility to pick an arbitrator that is well-versed in the area of sports you want to resolve a dispute in. You can have someone that is well-versed in basketball or someone well-versed in football to resolve your conflict, and then in a short span of time, it can be resolved. Also about mediation. Mediation is a little bit more simple, is less simple than arbitration. It's not as formal as arbitration. It's more of a roundtable, let's discuss this. And then sometimes the only thing about mediation is that the result or the conclusion of the mediator can be, the result of mediation can be disputed or can, I wanted to use the word appeal, but yeah, can be appealed or can be, there can be a lot of issues with the result of mediation. So arbitration has always been the go-to for resolving conflicts. All right, so I'll speak about CAS, that is the Court of Arbitration for Sports. An application can be made to the CAS against decision made by any sport federation authorized to make disciplinary sanctions, decision in sport, and all commercial disputes related to the implementation and development of sport. CAS has proven to be the go-to for all sports disputes because it was is seen as one of the highest arbitration centers for sports disputes. I'm trying to move as fast as possible, so because we have quite a lot of things to sort out. Okay, so how to become a sports arbitrator? The minimum education requirement to become a sports arbitrator is a 4-year bachelor's degree, which could be in any area of your choice. It could be law, it could be any degree of English, political science, intellectual property, and any other degree of the person's choice, but as long as the person has a degree. And then the person or anybody interested in becoming an arbitrator, especially a sports arbitrator, will then go on to complete all the licensing and certification. And of course, it is also recommended to take the Jiipcc classes, because I don't think you can get some of these detailed classes anywhere else. So you can have a full understanding. Well, that is a certification. That's one of the certifications that is recommended. And if, for instance, in Nigeria, we have the Chartered Institute of Arbitrators. They have a list of, I'm going to use Nigeria as an example because that's where we are right now. They have a list of, Chartered Institute of Arbitrators have a list of requirements to take. It could be the international arbitration or domestic arbitration. Well, international arbitration is recommended because sport is worldwide, not just in Nigeria. And then Chartered Institute of Arbitration is not just in Nigeria, it's actually in the UK. The main office is in the UK, and then they have offices here in Nigeria. And then wherever you are in the world, is just to understand their system and to understand which arbitration academy is in effect in that place, and then follow all their minimum requirements and then register. And then what also is recommended is that you take, you have a mentor arbitrator, an arbitrator you're following, and just like any other field of expertise, you start learning more, reading more, even after all the certifications and the licensings, then you start reading more and learning, because no sports person really would want to just take their issues and bring it to you if you are not well known in that field. We're talking about Gardiner and how he said the sports world is a really small world and everybody knows everybody. You just hear from one person to the other person, oh, this person resolved our dispute through arbitration, is well versed in this area. And then if you want to be called or be known as that as well, you have to be known, the networking, the visibility, you just have to show up. So that's about it as well. Okay, we're talking about how, sorry. A sport arbitrator is an arbitrator specialized in the field of sport. As I said, sport arbitrator's goal is to find a beneficial solution for both parties on a legal basis. This often occurs if there's been a breach of contract or if contract needs to be negotiated. Excuse me. We understand that, I'm going to use football as an example. We season in, season out, you hear some players being transferred, some players being bought, some players being loaned, and there are lots of legal things involved. There are a lot of agreements to be signed, a lot of payments to be negotiated, a lot of time span to be negotiated. So if any line or any clause of the agreement is lost in interpretation, or if there's any dispute as to the negotiations or breach of contract, instead of taking it all the way to court, or just taking time in, because season is not going to wait, or the league is not going to wait for anybody to resolve any conflict. So ADR is always arbitration is always recommended. Under ADR is always recommended, so that all these things can be resolved. And it's also recommended because, for instance, now in this, for instance, a player could be in a team this season, and then the next one is another team. Now the team has changed, but they are still all players. So anonymity, bad blood, for a lack of better word, should not be something that should not be allowed, or should not be fanned to flame, because it seems that's what was the important thing in sport. Most of the sport that we have, basketball, volleyball, all those, they are team sports. So it's always encouraged for that all disputes should be resolved amicably and as soon as possible. All right, only arbitrators from the closed list of arbitrators published on the CAS website can arbitrate cases at the Court of Arbitration for court. So as I said, you have to be in that system. You have to be in that world. You can't just call yourself a sport arbitrator. You have to be in the system. But for CAS, I know there has been a lot of arguments about it, that is a little bit closed and everything. But it has to be like that, because the world, though it's small and simple, it's extremely complicated, and there's a lot of money, and there's a lot of people involved. There's a lot of careers that are involved in this thing. So it could be a ripple effect. If one person just mistakenly signs on a negotiation that is detrimental to another person, it could lead to a whole ripple effect of another person getting affected. So some people, or there's been arguments to the fact that it's better it's closed, and then people that will get into the arbitrators will be screened and be the best people as much as possible. So I'm going to go to the case studies. In March 2011, CAS decided on a case between I'm sorry, I can't see my screen anymore. I don't know if anybody can. Can anybody still see my screen?
Yes,
I can see your screen.
Oh, wow. How come I can't see? Oh, boy. Okay, yeah, I can see it now. Sorry about that. Yes, I was talking about the March 2011 CAS decided on a case where it suspended two Italian cyclists, Franco and Petro, for 2 years based on evidence from their blood profiles. So it's just showing that CAS is not just about negotiations and disputes but also if there's, as I said, there was a part already earlier where if there's anything about your federation, your sport federation or sport governance that is not that you don't find fair, it can be taken to CAS and it will be resolved. And in 2018, the World Anti-Doping Agency appealed to the CAS after FIFA reduced the suspension of the Peruvian national team captain Paulo Guerrero. Guerrero had tested positive for cocaine after a World Cup qualifier against Argentina after ingesting a tea containing the substance. Guerrero was initially suspended for 12 months, but this was later upped by FIFA's appeal committee. WADA in turn appealed to CAS and they imposed the 14-month ban in May 2018, which will cause Guerrero to miss the 2018 FIFA World Cup. CAS confirmed the existence of an anti-doping rule violation, but also accepted that Guerrero was not trying to enhance its performance by ingesting the substance. The panel had considered that the player did bear some fault or negligence, even if it was not significant, and that he could have taken some measures to prevent him from committing the ADRV. So there were a lot of things to be considered. Was he at fault? Was he negligent? And then it went on until a fair decision was made so that to prevent other players from, using the blanket of this tea, I did not know, so it's CAS has given us, like all this precedence, like sports precedence for other federations or for other, and this was done through arbitration, which took very less time. So this is our suggestion. In conclusion, arbitration has proven to be an extremely successful method of resolving sporting disputes, and as a result, has gained the favor and confidence of the sporting world. This success has inevitably led to massive increase in the number of sports arbitrations taking place in recent years. Unfortunately, the expectation of the sports community, created largely by the high-profile activities of the CAS, are somewhat at odds with the reality of many national-level sports dispute resolution bodies, as well as some of the international arbitral bodies that have been created by international federations. To this end, it is arguable that the bulk of resources, both financial and intellectual, should be dedicated to the establishment of a high-quality national court for arbitration for sports in every country for the resolution of national-level disputes, and a similarly high-quality arbitrary body in each sport to resolve international disputes. Thank you. That will be all from Group 4. Thank you very much.
Thank you so much for that presentation. Thank you so much. It was really educating. And I particularly took note of the part where you say we have to take Jiipcc classes. Okay, please, the presenter for Group 3, are you present now?
Yes, please. Good evening.
Please take over. Thank you.
Okay, good evening, everybody. Sorry, I'm waiting for for the screen to be shared so that everybody can benefit from the discussion. Hey, please, could you please share the screen? Share your screen, please. Hello?
Yeah, I'm on that. I'm doing that already. Please, could
Hello?
someone, yeah,
I can't see it.
okay, can you just start? I think it will pop up
Oh,
soon.
okay. We're the members of Group 3. I'm representing Group 3. My name is Jimmy Robertson and So the topic for consideration here is broadcasting in sports. So just for for context, we should understand that, in every sporting event, whether it's, a local sporting event or, an international sporting event, there's actually a need for media coverage. There's a need to actually, not just have the event on, on the stadium or on the field or the pitch, but whatever the venue is, but also make it available to people who cannot, be physically present through, let's say, television lines or other methods that, actually make these sporting events accessible to, people that are at home, people that are, that can't actually make it to the venue. So that brings us to broadcasting, the idea of broadcasting. So broadcasting is essentially trying to, it's the, summary of the meaning of broadcasting is, the rights that is reserved by a company to provide media coverage to communicate or disseminate information. And then we continuing it, looking at this from the perspective of sports law, sports and gaming law, we would understand that broadcasting has to do with, disseminating information or disseminating information regarding sports, essentially. So going forward, please, could you go to slide 3? I think I actually wanted to draw our attention to. Please move forward, please. I wanted to draw attention to something. But meanwhile, we should understand, based on what everybody has been saying so far, we should understand that, the sports industry is actually a lucrative one. So definitely, if you're going to actually have a broadcasting company, definitely there's every likelihood that you are actually going to make profit out of it. Now, in the previous slide, there was, this statistic as to, the value or the worth of broadcasting in the sporting industry. So I wanted to draw our attention to this. It says under the International Convention of the for the Protection of Performance, Producers, and of Phonograms and Broadcasting Organizations, under the Rome Convention of 1961, broadcasters have exclusive rights for 20 years to authorize rebroadcasting, fixation, reproduction, and communication to the public of their broadcast. So essentially, this Roman Convention gives exclusive rights to broadcasters to manage or to have some sort of control as to how they want their broadcast to be reproduced, how they want it to be made use of by other individuals. So the time frame that he allows is 20 years. Now, please, could you go forward, please? Okay, so the so just like other intellectual property rights where you have a right to do something and then there's an infringement of the right or there's a breach of that right that the law has accorded you with. And broadcasting rights also has their own name for or their own name for infringement. It's called signal piracy. Essentially, signal piracy is when somebody has their own exclusive right and then you try to infringe on that. You try to sabotage that their right. For instance, sometimes if you log on to YouTube, usually you have people doing live sharing of sporting events. Meanwhile, they don't have the broadcasting rights or they don't have any, reservation, any, authorization to actually make those broadcasts. My brother used to tell me that, those people, they don't normally, last so long. The broadcast for like, as long as the match lasts and you cannot actually have access to it after the match. I don't know if you understand. But that's how signal piracy works right now. So moving forward, we'll also be talking about ambush marketing. So ambush marketing is actually like a strategy that broadcast that is employed by some companies that imagine a scenario where an event is being sponsored by Adidas now, and then um, Nike comes up from nowhere as like they come up and then they try to like start pushing agenda for their own brand. That's the whole idea behind ambush marketing. Now, in as much as everybody has their rights to advertise their own brand, in as much as they have the rights to seek for, should I say, patronization from consumers, there's like a limit to it because number one, you are not sponsoring this event. You don't have any, should I say, direct relationship or direct transaction with the organizers. You don't have that kind of contract or that kind of agreement. So your involvement now is considered ambush marketing. Please, could you go forward? I think we had an example on ambush marketing. Okay, the example, please, one slide up, please. The example we made use of is using both in 2016 during the Olympic where he kissed the Puma shoe he was wearing. Meanwhile, the organizers, after he won the 100 meters race, he kissed his Puma shoe. Meanwhile, the organizers were like totally different people altogether. So moving forward, we're going to like examine the advantages of ambush marketing. We're going to examine the disadvantages of ambush marketing. So please, could you move forward, please? So for the advantages of ambush marketing, would look at it under three headings, just as the disadvantages. Ambush marketing can be very clever because this actually you trying to actually cut corners is actually somehow creative and innovative. Ambush marketing campaigns can go off script. Usually, there's no like clear cut, or pre-arranged method in which they want to actually carry out, or any strategy that they have in mind to carry out ambush strategy. So there's every likelihood or there's this tendency to go off script. And then ambush marketing can also make consumers change their perception about the brand. This is somehow self-explanatory. So these disadvantages of ambush marketing, we have it can be very expensive because you trying to cut corners, definitely you will definitely incur cost. And then time and speed are factors in ambush marketing. So ambush marketing is not something that you could just do. You are also limited by time and speed. So definitely, in conclusion, we have tried to like summarize our presentation by saying the future sports in Nigeria, especially as regards ambush marketing, in a special legislation being put in place to check the activities of smart ambush marketers. So essentially, we are recommending that there should be a legal provision for ambush marketers and the extent to which they can operate for for us to either legalize it or not, but at least the law should have a position on the issue of ambush marketing essentially. So thank you.
Okay, thank you so much, sir, for making it brief and informative. Thank you so much. At this point, we are done with all the group presentations. I would like to invite Mr. Marks for comments on the group presentations before we go into the questions, sir. Mr. Marks, sir.
Okay, yeah, thank you. Hope you can hear me now.
Yes, sir, we can.
Can you hear me now? Okay, I don't have an idea. How many minutes do I have for this?
So you can just do that in 2 minutes, sir, so we can go into the questions.
Sorry, we have two mentors. So the second mentor will still make his contributions and comments. So, sir, let's say you have...
Okay, very well. So first of all, let me comment.
You have 8 minutes, sir. You have 8 minutes.
If I'm correct. 8 minutes. Okay,
Yeah.
thank you. Thank you. That's fine. I'll try not to use up all of that so we can have more time for the question. So thank you. I've been in Jiipcc from the very inception, and I must really commend this particular cohort. I mean, you guys have stepped up the game a couple of notches. In fact, this space, I might be enrolling for the next good presentation. I mean, your slides were really beautiful. I loved this, the layout and everything about the slides. Your presentation was really wonderful as well. I mean, there's really nothing more I can add, just to say, yeah, you are correct that, IP in sports is a huge deal because sports wasn't as profitable as it used to be before until sports people now learned how to use IP to, extend their revenue streams, from their IP. So merchandising, for instance, which is what I believe that was Benjamin Peter from Group 2 spoke about now. That's another huge area where sports, has opened a whole new stream of income for themselves, arising from just from sports. So you could see that regular sports stars now have, another stream of income that makes them a lot more money than even what they get as wages from their respective teams that they play for. And then, of course, Group 4 talked about ADR in sports. That was also a good presentation because when it comes to sports, just like Titulala mentioned, people don't have the time for litigation. I mean, if you are, sports stars, they have a very limited amount of time in the limelight. So if they have started going to court and, waiting for the judiciary that takes forever, I mean, by the time the judgment is handed down, the man has already passed his prime and he might not be able to perform any better than he would have. So speed is of essence when it comes to resolving disputes, sports-related disputes. So just one aside, there's a Nigerian lady, Beverly Agbakoba. I know some of you might know her. If you don't, please search her on LinkedIn and try and become my friend. She's somebody who's also blazing a trail in ADR in sports. So she was listed as one of the emergency mediators for the last Commonwealth Games in Birmingham. She was on that panel. I don't think they were called into action at any point in time. What I mean, it tells you she has gone far. So we are watching her very soon. We are sure she'll be listed when the Olympics comes around or the World Cup comes around as one of the mediators or arbitrators who are empaneled to hear and resolve. And of course, when it comes to those kinds of mediation, they give instant, they bring instant results because they want within the lifespan of that event. In fact, sometimes within 2 or 3 hours, a dispute arises they must be empaneled and they must come up with a decision instantly to ensure that there's no slowdown of the games that are currently ongoing. So, for instance, if somebody is disqualified for doping, the person could immediately bring up an appeal to them, and they're able to resolve that instantly on the spot and ensure that the games can continue. But there's just something I wanted to clarify with Titulola's presentation. When it comes to mediation, yes, you were right to say the decision that comes out of mediation, they are not exactly, some people say they are not binding, but they are binding. But why people say that and they are not wrong is that unlike arbitration and litigation, where the resolver of the dispute, that is the judge in litigation or the arbitrator in arbitration, they hand out a decision. Whether I like it or not, that decision is binding on you. But in mediation, what comes out is what we call a settlement. It is kind of settlement agreement. So both parties have to, in a sense, agree to it. The third party who is resolving your dispute in mediation cannot force a resolution down anybody's throat. It's to hear the parties and facilitate them reaching a settlement. So in a sense, it's not like arbitration or litigation where if somebody's trying to misbehave and is not wanting to comply, they could force a decision down his throat. So in mediation, you can't force a decision down people's throats. But on the flip side, why mediation has an advantage is that typically when people agree to a decision, they are usually more willing to enforce it. So you would find less resistance than where you force a decision down people's throat. Then people could begin to resist it. They go to court and try to hold up the process. So mediation for me is in a sense better, and I would encourage you to tilt more towards mediation. Why? The reason I'll say that is because arbitration can be really expensive. I mean, just this week, I had somebody come to complain to me. He has an arbitration, and there are 3 arbitrators presiding in that proceedings. And each of the arbitrators is asking to be paid 7% of the value in dispute. And the value in dispute is just not too much, $100,000 US. So imagine you are paying $21,000 US to get, and you have to pay it upfront, and hope you get a decision in your favor. And the arbitrators also award costs. So arbitration can be really expensive. So, I tell people that you might be better off looking at mediation, except it is really high value, then arbitration becomes worth it. But when it's low value, and also when it's low value, ensure you always provide in your agreement that there should be one arbitrator. Because if there are 3 arbitrators, you have to pay all 3 of them. Remember, in litigation, the government pays salary to the judges. So you're only paying filing fees. But in arbitration, you are the one renting or hiring the judges, you are paying their wages. So it could be quite steep sometimes. And then just the last point on group 3, broadcasting in sports. Wonderful presentation also from Robert. So one thing I wanted to mention was that when it comes to ambush marketing, it's actually a huge deal. And I believe Robert mentioned that there's no clear law regulating ambush marketing. And indeed, you are right about that. But however, what I would just want to add is that other existing laws, for instance, the laws on infringement of trademark, of copyrights and all of that, in a way protect an organization against ambush marketing. Because if you have not been given the right, for instance, to be one of the official sponsors of the World Cup, and you decide to begin to paste on social media and say, maybe XYZ Nigeria Limited, we support the Super Eagles, and you put the logo of the World Cup there, you put the logo of the Super Eagles there. Yes, there's no law exactly that says ambush marketing is wrong, but in your ambush marketing, you have violated the trademarks by pasting those trademarks. So even if there's no law that says ambush marketing is exactly wrong, there's collateral, there's collateral laws, like you have not taken a license, you have to using the copyrighted works of that organization, that's copyright infringement. Using their logos and all, that is already trademark infringement. So there's another, but I agree with you that there is a need to have a specific law on it that balances that. Because sometimes also people just want to promote that sense of patriotism. So I mean, if Super Eagles goes to the World Cup and my law firm just wants to wish them well, I mean, we shouldn't be stopped from doing that. But if we now go beyond wishing them well and we're trying to benefit by creating a link between us and the team or the games, then at that point we are crossing the line. So it's just good to create that balance. So I agree with Group 3 that we should have a law on ambush marketing that balances the competing rights. So thanks, guys. It was wonderful, and of course I look forward to the Q&A session.
Thank you so much, sir. Thank you so much for the enlightening period. Please, sir, Amobi, please, are you here, sir?
Yes, I'm here.
Okay, sir, please, you have the floor. to speak on the presentation so far.
Okay, thank you so much. First of all, sincere thanks to Juliana for inviting me, and special thanks also to my friend Max. I've listened to him, and I was about telling you guys to give him more of my time so that I would continue to listen. Your presentations were wonderful, and indeed, there is nothing to add or remove. But as lawyers, we must always have comments, But my comments will center more on what we, talked about on arbitration or dispute resolution in sports. Being someone actively in sports law practice, I can tell you that it's interesting because you don't need to fight to get your pay as a lawyer now in sports law or as a lawyer in active arbitration before the Court of Arbitration for Sports or the FIFA Dispute Resolution Chambers. And I'm happy my brother Max talked about Beverly and all she has been doing in sports and entertainment law. And it's important for us here to know that this is a growing aspect of law and people should embrace it. Just 3 weeks ago, we went to arbitration against Cincinnati of America. We were representing Rangers. They failed to pay training compensation and solidarity contribution. And it was easy because what happens now is that sports institutions now create means of settling disputes. For instance, in FIFA, you have the FIFA transfer matching system where you upload your documents, you make your claims, and then the arbitral panel or the FIFA dispute resolution chambers will look at it, ask the respondent, Cincinnati in this case, to file its own brief of argument, and then within 2-3 weeks, you are home and dry. It's interesting, really, because before now, you have to fight against big clubs, you have to fight against big institutions to make sure that these things are resolved. So you are really on the right path, and I can only say that you are in to enjoy what most people, especially those who started this race before us, did not discover. I can't remember how many times I've been to a regular court because I decided to embrace sports law and a bit of entertainment law as well. When Juliana talked to me about the IP aspect, I said, yes, this is time for me to go and read up as well and, know more about the rules governing intellectual property. And it's been an interesting time listening to us talk about this, talk about the brands of Liverpool. I got a little bit upset because no one talked about Enugu Rangers, registering the Never Say Die, or no one talked about Kano Pillars registering the same Mesugida and all that. Even Mountain, I know most people are in Lagos, Mountain of Fire Ministry, they have a football club, and I know they are popularly known as, is it the Church Boys or something? But in all, it is important for us as young people to continue to, sharpen our minds, to continue to expand our thinking. When I decided to go into sports law, for instance, I never knew I was going to enjoy myself, get award for football clubs, and you take as much as 25-30%, and they are happy because they feel the money would have been lost, So people are encouraged to come into this. Then I enjoyed the presentation on broadcasting in sports because you see, a lot of times we relegate the importance of what the media people do, journalism, what happens, how they project the sports, be it football, tennis, basketball, volleyball. But now you guys have brought it out. You've brought out the concepts governing broadcasting in sports, and it's now for us to look at it again, continue to expand it. We spoke about the ambush marketing and all that. I know we have a question on that and the financial implication. When we get there, we'll talk about it. But one thing is important. There are no hard and fast rules when it comes to sports law, intellectual property practice, especially when you are practicing. You find that most times you are in the tribunal, maybe the FIFA dispute resolution chambers or an arbitration panel, and a new rule is evolving, a new law is developing. You know, when you look at Caster Semenya, for instance, and how they turned the whole thing back and forth. I wrote an article on, you know, the role of color when decisions are being made by some of these international organizations, maybe the CAS and all that. I know I asked the question, I asked whether if Caster, for instance, were to be from America, whether she would have been asked to go and reduce her testosterone and all that. But these are things that we need to really think about and continue to push and push and push. Now we are happy we are getting Africans, especially Nigerians, being recognized. My brother talked about Beverly, and then there is a barrister, OK Obi, at the NFF, who is also doing a lot, and a lot of other Nigerians. So we need to continue to push, and sincerely, I am very happy to be here. I hope I am now an automatic member, Juliana.
Yes, sir.
All right.
Yes, sir.
Thank you so much. Thank you.
Okay, thank you, sir, for speaking on the different groups. Thank you for enlightening us so much more. We'll go into the questions section now. I'm going to drop the questions in the chat box so everyone can see. Okay, thank you so much, Mr. Hussein, for that. Thank you. So we'll start with question 1. I think we'll start with you, sir. Sir Amobi.
Yeah.
Let's just, yes, sir. Thank you. The first question
about you know, enforcement of a trademark outside one's jurisdiction, especially if one is outside Europe, right?
Sorry, sir, I didn't hear you clearly.
Question 1.
Yes, sir.
Talking about enforcement of breach of trademark outside Europe.
Yes, sir. Yes, sir.
Okay. It's interesting because when you look at the World Intellectual Property Organization and, you know, the various rules, regulations governing protection of this right, you will find that on the surface, these rights are protected, especially when it comes to domestic regulations. You know, you cannot breach when someone has registered his trademark and all that. But what happens if that breach happens outside your jurisdiction? You know that there are over 117 member countries who have agreed to enforce trademark rights across borders. And I don't think it's going to be a big deal now, especially if the jurisdiction where such breach has happened is also under, is covered under the 117 countries, or the country where the breach takes place is a member of the World Intellectual Property Organization. But like I earlier said, these rules are subject to changes. You know, merely registering your trademark will not help you to stop infringement in a foreign country. You know that. Infringement will definitely happen, but how you go about it matters. So, and as we all know, trademarks are fundamentally domestic rights. They are created by domestic statutes and They are also enforced by domestic courts. So I think it's a matter of protocols, it's a matter of following the process as the case may be. You look at the rules, you look at the principles, and then you try to find out how you can go about this. Again, you need to also know how this registration process works, especially when you want to strive to get this protection internationally. I know, for instance, in some jurisdictions, you talk about having the domestic trademark through the relevant organizations or the relevant government agencies saddled with the responsibility of registering these trademarks. You can have a unified trademark application, and they call it the international application, with the International Bureau for World Property Intellectual Organization, that is WIPO. These applications are also subject to various fees, and the importance now would be that when such breaches arise, you can, come out to say, okay, you've got your international backing, you've got your international application. But one interesting factor or feature about the question is that the question is talking about an athlete now. The question is talking about a sports person. Maybe we say a C. Ronaldo or a Messi or a John Mikel Obi coming to lay these claims. How can the person's rights be protected? People will argue that they are too big to start thinking of what happens in a village in Kenya or what happens in Uganda, but it is these little things that grant us the protection for the future, that grant respect to the laws that govern us. When we went against a club in Turkey, for instance, Gaziantep of Turkey, we represented Rangers against them, and people were like, why are you going against the Turkish side? They don't respect rules. But I made up my mind that even if it was going to be my last work on earth, I was going to do that. And we were able to get the award. We stayed on them until they paid, and they labeled in the Turkish paper that Nigerian lawyers are very difficult. And it's about opening your mind to possibilities. The questions raised may be difficult. No one may know how to approach it, but you find that when you try to test the waters, it could be in your favor. I think that's my comment on question one. I don't know if Max would want to help me.
Thanks so much, Amobi. I'll just chip in quickly because I understand for sake of time. And apologies, I didn't know you were on the call. I mean, you are just being modest. I mean, this is one person, anybody who is here today, you have caught this man, hold him. That is, when I say hold him, because, this is a subject matter expert when it comes to sports law. If you have held Amobi, just forget it. If anything you want sports law, once you have held this man, you have gotten your answer, because some of us, we are generalists. I'm just an IP lawyer. So, and of course, I understand because I know IP, I know how IP relates to sports. But Amobi is a transactions man who understands sports first and then law second. So, once you have held somebody like this, you need to hold on to him. And like I always tell people, IP has gone beyond that era of just being a generalist. You need to understand IP in the context of an industry, and people like Amobi, you can understand IP in the context. And sports industry is one area where IP is large. I mean, IP in sports alone can give you work for 2-3 lifetimes put together. So just to quickly chip into that question. So yes, when it comes to this question, it's first of all a basic thing you must remember from IP law. IP rights are territorial. So it means you can only, in a sense, enforce your IP right, strictly speaking, only within the jurisdiction where you have registered it. However, there are international mechanisms that allow you have a registration that applies in many countries. So for instance, what we call the Madrid system allows you to register a trademark in many countries simultaneously at the same time. But even at that, remember that when you are enforcing that right, you're not enforcing an international right in that sense. You are simply enforcing the right as registered in that particular jurisdiction. But however, sometimes because of how IP breach happens, even though a person is in Europe and a person in Nigeria breaches his trademark rights, typically you may find that that person who breaches right in Nigeria is selling to some people in Europe. So for instance, the person is merchandising a product that involves his trademark and is selling to people in Europe as well. So there's still a sense in which he could enforce by bringing an action even in Europe. So maybe not necessarily coming to a court in Nigeria per se. There are, of course, other ways. For instance, if the infringement is done online using domain name, for instance, it simply goes to WIPO, like Amobi mentioned. WIPO has a special center called a special system called the UDRP, Uniform Domain Name Resolution Protocol, where you can enforce and take back that domain name that incorporates your trademark. So there are many ways to enforce, but it's not a simple, straightforward answer. And it doesn't mean that just because you're in Europe and the guy is in Africa, you are you have nothing to do. There are other ways to always be able to still get to that person. For instance, even if your trademark is not registered in Nigeria, you are European and the person infringes in Nigeria, you could bring an action in passing off, which still protects your trademark, even though it is not a registered trademark so far as Nigeria is concerned. You just have to show that that trademark has value. It is known all over the world, including in Nigeria, and that the person, by doing that, is passing off as if he has your permission to do what he's doing. So there are many ways to still go about it, even if it's not cut and dry. So thanks, Sorian, for taking extra time on that.
Thank you, sir. Thank you, Mr. Max. Thank you, Mr. Amobi, for that question. Please, before we go ahead to the second question, please, the mentees and everyone, you are encouraged to turn on your videos and take a screenshot, make a post on LinkedIn, tag the mentors, tag Jiipcc, and please just make a post on LinkedIn, say what you learned from today's session. Thank you so much. Okay, we'll go ahead. While that is being done, we'll go ahead to the second question. Please, Mr. Max, you take the second question. What other IP rights arise aside design, patent, trademark, and copyright in sports?
Okay, yeah, thank you for that. That's also a good question. So yeah, when it comes to IP rights, like we know, the four that have been mentioned in the question are the traditional IP rights. We call them the traditional rights because, for instance, in a jurisdiction like Nigeria, those are the only rights that have a specific law governing them. That's copyright, trademark, patents, and designs. But however, we know that there are other IP rights, the non-traditional IP rights. So for instance, I just mentioned one of them is what we call passing off. So passing off essentially is a way to protect unregistered trademarks, but it's not purely trademarks because it's more about protecting your goodwill and stopping a third party from passing on, giving the impression that his products or his services are coming from you, whereas they are not. So that is one right that plays also in the sports area. So for instance, the group 3, I believe, group 2, sorry, that talked about group. Which of the groups? I think it was group 1. Group 1 mentioned about group 2, sorry, talked about character merchandising. So for instance, there's what we call image rights. So infringement of image rights also is another kind of IP right that is also very much applicable in sports. So I mean, if I decide to start a small football academy here in Nigeria, and then on my signboard I have a big picture of CR7 with his name, with his image and everything there. That is, in a sense, I'm using his image, I'm misappropriating his image right to create the impression that he's affiliated with my sports school. So you could see that image right plays there. Then, of course, trade secrets is also another huge area that plays in sports law as well. So training methodology, for instance, the unique way you train and some of the secret things you use in your training schedule, for instance, is also what you can protect by way of a trade secret. Of course, you don't have to register a trade secret. You just have to have enough mechanism within your organization to keep it secure and secret from disclosure to third parties, and that alone grounds enough protection. So it could even be things, even sometimes like the kinds of nutrition, for instance, that your nutritionist gives to your athletes, that could also be protected by trade secrets as well. Then geographic indications, IP right, that also could play in sport. So of course, we understand that geographic indication simply talks about protecting those unique features that are tied to the geographic locations, maybe sometimes environmental factors, climatic factors that create particular goods or services from a unique geographic location. So that could also be something. So for instance, Team Nigeria, for instance, in a sense, even apart from being a trademark, also could be, in a sense, a type of geographic indications, even though they are called more like designations of origin. So a person using that Team Nigeria brand, using a Team Nigeria logo without authorization would, in a sense, be breaching the geographic indications, even though, like I said, that's not geographic indication in its strictest sense, but it's also an aspect of it. And of course, even traditional knowledge, traditional cultural expressions also are all things that could play out in sports. So, for instance, I believe there's been a case where the mascot used by I think it was the Yankees also in the US, the Yankee team in the US. The Native Americans took issues against it and said that it was a misappropriation of their traditional traditional cultural expressions. So you could also see that TK and TC also has a part to play in mascots and in costumes that sports and athletes would also use. So that's also another way IP comes in as well. So for sake of time, I'll stop at this point.
Okay, thank you so much, sir. We'll go on to the third question. Okay, well, Mr. Amobi, sir, please, would like for you to take the third question. How do we resolve the issues of foreign awards in arbitration, especially in sports disputes?
Okay, you see, sports disputes now, like I earlier said, they are evolving. Settlement of are evolving. I have given two instances of international dimension. We are practically directly involved in, and you find that because of how the laws have changed over the years, it's no longer difficult. All you need to do is to follow the rules. In Nigeria, for instance, if you have a domestic matter that borders on maybe arbitration and all that, and you get to the highest level let me take, for instance, Nigerian Football Federation. By Article 70 of the NFF statute, you can go to CAS when you are not satisfied with the decision of the appeals committee or something. And you know that when you go to CAS, these awards are binding. And because of the sanctions you've agreed to, that when you don't keep to the terms of these awards, that you will be sanctioned. You can get a life ban, you can be banned from registering players and all that. You've had instances, for instance, where Barcelona, they were asked not to register players for some time. You've had instances where clubs were asked to pay a certain amount of money. And these things are a pointer to how we've evolved since the 80s, when the Court of Arbitration for Sports came into existence. Like I said, one thing we must know is that tomorrow the rules might change. Yes, years ago, we didn't have something like the VAR, for instance, or the goal line technology. The way these rules are changing technically is the same way the rules are changing in the legal field, the legal aspect of sports. So it's for the lawyer, it's for the law enthusiast, it's for whoever that is so passionate about, the legal aspect of all these things to find out what happens in it. So you will find that most times, all you need to do practically is to ask one or two questions, look at the rules to know if the rules have changed. I know that by next month, there will be another regulation on the status and transfer of players. So you need to get it to know what they've added or what they've removed. So these are the practical steps that one can take towards making sure that we are always on the right track. And when you talk about enforcing foreign awards, it's not that distinct from the normal commercial arbitration. Okay? I know in normal commercial arbitration, the UNCITRAL model and all that. But when it comes to sports, for me, in sports, it's easier because it's regulated. And like you earlier pointed out when you were making your presentation, we know ourselves, okay? You can pick up the phone to say, hey, the sporting director of Valencia, we've won you in court. When are you paying? And you laugh over it and he goes to follow up. But in normal commercial transactions, it's heated, is so heated and all that. You'll find also that in sports arbitration, the arbitral panel sometimes can offer a middle point. And in the spirit of the game, you talk to each other and you get to that middle point and matters are settled. Unlike what you find in clear commercial arbitration, where people are talking of, protecting their business interest. In sports, you are protecting a business interest, but the spirit of sports is always preserved when you are talking about, enforcing foreign awards. It's also important to note that Africa needs to also rise when it comes to foreign enforcement, when it comes to award. Most sports entities in Africa don't know the rights they have, okay? Unlike their other counterparts in Europe. In Europe, for instance, you find a Division 4 club claiming training compensation and solidarity contribution of up to maybe 50,000 euros to 150,000 euros. But in Nigeria, you find that a club that may have trained Victor Osimhen from 12 to 15, they don't even know that they have a right. They have money waiting for them at the FIFA clearing house. So it is now upon us, people who are enthusiastic about the development of this law, people who are enthusiastic about making sure we protect the interest of Africa, to continue to talk about it, write about it. Your presentation alone, you guys can even choose to send out flyers, and you are hosting a talk show on Instagram and people will join. You are inviting sports clubs and football clubs in Africa and Nigeria to come listen to you guys. And one thing I will say, I'll use this opportunity of answering this question to say is, never think that anything you've researched on, anything you've said doesn't make sense. Maybe because you are young or you feel, I don't know if you've all been called to the bar or maybe you've not been called to. No, what you say could actually be what would win the matter as far as I'm concerned. So you need to understand these things, you need to understand these arguments, and you need to understand that this practice is a living practice. You can swear the tribunal by your argument. Again, when you talk about enforcing foreign awards in sports, there are some countries that are difficult. How do you follow those countries that are difficult? Countries like Turkey, countries like Kuwait, like Saudi Arabia, like Egypt, where I am currently. These now brings about your street credibility. Yeah, let me use that way, your street credibility. You write mails and you copy FIFA, you write mails and you copy, you keep writing these mails and you keep reminding them of the sanctions. And then your goal is to get your money for your client. Your goal is to make, somebody's writing Egypt, God, when you want to come to Egypt. So please, that is it. I believe I've really laid a foundation for your understanding of that question. And like Juliana said, and like Willie said, feel free to reach out. We can always talk about this and find a way out. Thank you.
Unmute yourself, Minnie.
Oh, thank you. Thank you so much, sir. We'll go ahead to the next question. Please, I would like to chip in that the mentees should not forget to turn on their videos, take screenshots, tag the mentors, tag Jiipcc, and say what you've learned today. The fourth question, sir, the fourth question will go to Mr. Max. How is it expensive? Yes, how is it expensive for a company to engage in ambush marketing? Mr. Max, sir.
Okay, yeah, thank you. Yeah, so, well, the whole idea of ambush marketing, like the presentation had already made it clear, you are simply trying to pass off affiliation with a major sporting event when you have not gone through the hassles of getting a proper, signing a deal with the organizers to become one of the official sponsors of the event. Now, for the person who signs a deal to become an official sponsor, he pays a huge amount to the organizers. So, for instance, if you are going to be one of the headline sponsors of the World Cup in Qatar, Amobi, I'm sure you correct me. I don't think anybody pays anything less than maybe $5 to $10 million to be one of the major, or one of the major sponsors. So imagine for the other company who has not paid $5 or $10 million. All he has to do is just to get somebody in his graphics department to do a flyer. So maybe he pays 10, 20,000 naira for flyers to be done. Says proud supporters of Team Nigeria at World Cup 2022, or up Super Eagles for, of course, Super Eagles is not there, but so essentially he's not spending a lot of money, but he's getting huge advantage, because the moment he posts that flyer on his social media platform, for instance, a lot of people are seeing him in a new light and saying, oh, this company is also one of the people sponsoring the World Cup. That means there must be a credible company, and is indirectly making benefit and gains from that, because the people who paid the money to do that are also going to get a lot of benefits. But if everybody can just wake up, print a flyer and say, I'm a proud supporter of Super Eagles at the World Cup or the Olympics or whatever, or the reigning lady now, Toby Amusan of Nigeria, if everybody can just wake up and say proud supporters, or you do a picture and show that Toby Amusan is drinking your brand of soft drink, for instance, if you do that, then it means when Toby Amusan goes to meet Coca-Cola and say, Coca-Cola, give me 50 million naira in return for the exclusive right to use my image as taking Coca-Cola drinks, then it means Coca-Cola will say, look, everybody's doing it, so why should I pay 50 million when I all have to just get somebody in my graphics department to print a flyer? So that is why ambush marketing is an issue. So it's actually cheap to get into ambush marketing, because you don't need to pay any license fees, you don't need to pay any sign-on, any agreement fees, with the organizers of the event. You just simply do a flyer and maybe spend some money getting that flyer or that advert to go around. Maybe pay some money to television stations to play that advert, but you are not paying any fees to the organizers of that event. So therefore, ambush marketing is cheap, and that is why it's a problem for the people who are actually going to spend money to become recognized as official sponsors of the event. Yeah, thank you.
Thank you, sir. Thank you so much. I don't know if Sir Amobi has anything to add to that.
Yes, I would say that in one way, because when we talked about ambush marketing, I had to read up one or two things, and I got a very interesting story, which I would like to read out, talking about one of the earliest examples of ambush marketing. That's the bitter crisis that erupted between MasterCard and Visa, during the 1992 Winter Olympics, which was held in France. Already, MasterCard had paid for the privilege, Visa had paid for the privilege. They have entered into a contract. They are the official credit card sponsor of the 1992 Winter Games. And for months, they paid about $35.5 million in dollars, 2018. For months, they've been doing their adverts. Visa ran TV commercials advising American Express card holders to leave their AMX at home, as the Olympics don't take American Express. Technically, it was true. Tickets to the games could only be purchased with Visa credit card. However, Visa's aggressive ad campaign raised serious issues, which claimed that Visa's ads were purposefully misleading. They were suggesting that American Express cards were not accepted anywhere at the 1992 Winter Games. So what now happened was that AM Express soon launched its own series of TV spots, which featured the slogan, when you go to Spain, you will need a passport, but you don't need a visa. So the fight started. Then along the line, they presented another example, the example of Audi and BMW. Audi and BMW, and at the end of the day, you found out that when they put up their own advert on the board. BMW will put up their own, and in the end, they spent over $100,000 just on billboards, fighting, try. And you look at it, you find they've made expenses, they've incurred expenses. So I would say that is neither here nor there. For Max, it could be cheap. For BMW and Audi, they've spent over 100,000 USD trying to put up billboards. And when matters like this come up, you find that for those companies competing, it even goes beyond a matter of law. It goes now to the ego, to their egos, and trying to say we are bigger, we are better, and all that. I think that's the only thing I would chip in.
All right, thank you so much, sir. Please, still with Mr. Amobi, we take question 5. How can signal piracy be detected and interrupted since it's digital and it might be difficult to trace the location or address of the perpetrator?
Thank you. When the presentation was going on, my mind was just going to one website I used to resort to when things are hard. His goal. You know, and when you guys are presenting, I was just smiling, and I was like, okay, if I suggest now that IT experts should continue to research to block these loopholes, when I'm in a very difficult situation, how can I watch a game I want to watch? But the truth remains that when you talk of signal piracy, it can be detected, but detection is not the problem. When you detect, how are you able to curb it? Are you able to make sure such piracy doesn't continue? Okay, so I feel it's a question of advancement in technological protection that you enjoy. So I wouldn't really want to, waste time around it, because for me is a question for people who are interested in technology law, people who want to really find more about. For instance, here in Egypt, it's difficult to watch games through his goal. Although there was a way I managed to with VPN and and all that you could get. But in all, we need to continue to evolve. We need to continue to develop. We need to continue to try to see how we can, provide a stable regime, both for technology law, both for, enjoyment of sports, both for intellectual property. That is my comment on this. Whether it can be detected, yes, it can be detected. Whether it can be interrupted, well, it's a question of, it's neither here nor there.
Thank you, sir. Thank you. That was really enlightening, actually. We'll go to question 6. Mr. Max, please, you answer question 6. What are the significance of protection of image rights in relation to the rights to privacy and human dignity?
Yeah, thank you. So that's another good question, because the image rights as an IP right is still under a lot of clouds of doubt. So for instance, in Nigeria, we still, and generally even in the common law world, even including in the UK, where we get the common law from, there's still a lot of arguments whether image rights is indeed, an IP right that should and can be protected. And the reasoning behind that is, particularly when you look at it from the viewpoint of a person who is a famous person and who puts himself out there in the media. So the question that is asked is, does he have a right to now control, whether people use his image or not? And in a sense also is the fact that people do not necessarily have an exclusive right to, an exclusive economic right to their image in that sense, because to a large extent, all human beings share common similarities. So in a sense, if there's an image that looks like a person, there's that argument, should he have the right to now say only he can exploit it? And if you can also exploit it, then the idea is that, are you also now contradicting the fact that, these are inalienable features that all human beings have, and you're now trying to use those alienable features to now get economic gain. So there's a lot of arguments back and forth. But of course, image rights law has come to a point where it simply says, look, you only prevent people when they are trying to use your image to exploit your image for economic advantage. But where privacy and human dignity comes in is that typically when you have an image right claim, particularly for somebody who is not famous and popular, then the issue becomes, can that person really, because image right is only where you are famous, you are popular, and somebody's trying to use your fame and popularity to get economic benefit. So if you are not a famous and popular person, so I'm just a random person, I go to a mall, and then somebody comes in front of the mall, takes a picture of people walking in and out of a mall and puts it on a billboard. So do I have a right to now sue? So if I sue in image rights, it's difficult for me to get any claim because perhaps I'm not that famous or popular enough to say they are trying to use my image and all. But I could bring and add a claim for breach of my privacy and my human dignity. That now makes it a lot easier. For those who are Nigerians, for instance, you know that one of the quickest kind of cases to get through the courts is a fundamental right claim. So if I bring my claim under fundamental rights for breach of my privacy by taking my picture in a private moment to have my consent, putting it up on a billboard, like the recent case where a lady won a judgment against, I believe, was the PDP or the APC, one of the political parties in Nigeria. They took her picture, put on a billboard, and she sued and said, look, the way the picture was taken without her consent and the way the picture was projected made her look like some hopeless, poor person, and defamed her character. So she was able to frame a case around, privacy, breach of, our human dignity and all, and she prevailed on that leg, where she would not have prevailed on that image rights per se. So privacy and human dignity actually enhance the ability to protect your image rights where you ordinarily might not be able to prevail in just a pure and simple claim for image rights. And also added to the fact that you can also use a fundamental right procedure to get a judgment a lot quicker than a regular image rights claim you file and takes a long time to get through the court system. So that could be some of the intersections between privacy and human dignity and image rights. Like I said, there are a lot of other, almost what we call jurisprudential arguments, philosophical arguments behind why a human being should be allowed to benefit from the image that God gave him and all of that. So there are all kinds of funny arguments there. So image rights is still one of those laws that, we are not exactly 100% sure yet. And every time a new court decision comes out, it redefines the area a little bit. We begin to look at things from a different angle. So yeah, privacy and human dignity are good ways to also protect your image rights if you cannot get a claim in image rights pure and simple to pass through. Yeah, thank you.
Wow, thank you so much, sir. Thank you for that. I learned from the answers to that question. And I'm sure that you meant to learn too. At this point, I would like to thank you so much for dedicating your time to speak to us today. I'll hand over to Ms. Julia for comment for us.
I think a hand is up. Ogonna.
Yeah, somebody is raising. Ogonna, do you want to say something?
I have a question. Okay. My question is, in this image rights, Max just clarified us on. Do you pursue these rights like you do others? Do you file an application or something? Do you have, or is it automatic, just like copyright, under which pictures fall? How do you take your personal efforts what personal effort do you have to take to protect it? Or is it automatic?
Okay, yeah, thank you for that. Yeah, so from the viewpoint of the protection of image rights, yes, image rights is in a sense automatic if the conditions are met. You don't have to, there's no registry where you have to go and register your image rights. But of course, remember that some of your image rights could actually be registered if they qualify as trademarks. So for instance, a signature of a person, for instance, is one of the things you can trademark. So that would qualify as a trademark. You need to register it as a trademark to enjoy the fuller and easier protection as a trademark. But not every image could pass off as something you can trademark. So for instance, the silhouette, that's that black and white image like a shadow of a person. For instance, also another thing you could easily also protect as a trademark. But image rights in itself, pure and simple, you don't have to register it anywhere. You simply have become famous and popular enough. Somebody decides to now use your fame and popularity without your permission to make money. You're automatically entitled to go to court and file a simple action in tort against him for infringing on your image. So you don't need to register or have any formalities completed like you would for trademarks or for patents before you can enjoy protection. But however, some aspects of your image right that qualify for trademark protection, it is wiser to actually protect them. So for instance, I believe I've heard that Ronaldo has tried to trademark his celebration, the Sue celebration, that, so for instance, Air Jordan, that picture of Jordan flying about to dunk a basketball is protected as a trademark, even though it's a sense in, an image of him taken from one of his games. So if you are able to show, but remember that for you to be able to protect as a trademark, you must show that it's distinctive. That means it's not something generic and common. So the picture of somebody just flying to dunk in itself is generic. But if over time you can show that, look, I've been using this image and people have come to recognize that this image, this particular image of somebody, stretching to dunk is associated with my 6 seconds in the 6 seconds in the air. And over time, people have recognized that this is something that's connected to me, Michael Jordan. Then you can get trademark protection. Other areas, like I've mentioned, signature. The Trademarks Act specifically mentions signature as one of those things that you can expressly get a trademark for. So if you look at Guinness, for instance, there's a signature of Otto Guinness on Guinness, which is part of the trademark owned by Guinness as a company as well. So getting it into a trademark form actually gives you better protection. But even if not, then you don't need to register in any registry before you can enjoy or bring an action for misappropriation of your image right.
Thank you very much, sir, for that response. Please, I don't know if Mr. Mobi wants to say something before we round up today. Do you want to say anything before we round up?
Okay. Is this going to be my final comment?
Yes, sir.
Okay, thank you. Again, I would like to say a big thank you to all of you. Thanks for the presentation. I learned a lot. And thanks to Juliana for inviting me. Thanks, my brother Max. I'm happy because I can see our faces. And I'm also sad that I won't be at the conference in Lagos. I follow a lot. That's one important thing I want to say to all of us here. Take good care of your social media. Take good care of your social media accounts. They will give you a lot of money. You don't need to be a C. Ronaldo. You don't need to be a Messi or Wilfred Ndidi. I will tell you a story. Next month I'm going to the FIFA Masters. And I found that one of the things FIFA did before admitting me to the FIFA Master was that they took their time to go through my social media account, my Instagram, my Facebook, because on the interview day, one of the professors of FIFA asked me why I felt that the penalty call in Nigeria versus Argentina in the Russia World Cup was based on some elements of racism, because I had argued strongly that the FIFA were being racist about trying to protect Argentina to get onto the next stage. And, it was a question of argument. And at the end of the day, he taught me a lesson. You need to, continue to protect your social media is the first, point of call. Be you a lawyer, a doctor, mind what you post. I know we love to catch crews, right? We love to catch crews. We love to do stuff on Insta blog and all that. Fine, you can do all those things, but you can do them intellectually without insulting anybody, without casting aspersion, and that is it. Once again, I am so happy, so happy to be here and to have been granted automatic membership. So I don't know my number now on the roll. Is it number 34, 35? Let me register, write it down now. And please, anyone, feel free to reach out. I'm always on social media. Once your message pops up, I'll respond, at least for now. I know that from 15th of next month, it may take time because then I will be in serious academic journey for 1 year. But thank you so much. I appreciate.
Thank you so much, Mr. Amobi. I don't know if Mr. Max wants to say something as his final words before we close.
Okay, so thanks so much, Juliana, as always. It's always been a pleasure to be on this Jiipcc, Jiipcc mentorship. For me, it really helps me to also refine my craft, to try to always see IP from that from that real sense of IP. When you see IP in action in industry, it makes more sense. Like I keep telling people, the mistake the older generation of IP practitioners in Nigeria made was that they only looked at IP, as an aspect of law, and forgot that IP is only relevant when it leaves the field of law, enters into a particular business, and is able to make that business make profit. That is when IP actually has any use or value. So for instance, we are discussing IP in sports today. You can see that for somebody like Amobi, like I've explained to you now, this now is a subject matter expert who, himself has his law degree simply a ticket that has opened a whole new industry for him. So when he sits in the football industry now, he's talking to the people in the football industry as an equal, not just as a lawyer who comes in, but he has an edge over them because beyond understanding the football transaction and the football dynamics, he also knows the law. So he's able to add a layer to it. So I would encourage everyone who is here, look at IP from that viewpoint. For me, what I only decided was that because I've already gone far in litigation, so what I try to do is to ensure that I remain somebody who understands IP very well and also understands the litigation process very well, so that once IP issues arise in litigation, what happened before was that we had people who knew IP, but when IP came to litigation, they would make simple mistakes that somebody who is grounded in litigation would know. So you don't find out that when a judgment is being given on a serious IP matter, the judges are talking about a procedural mistake the person made. That becomes the fulcrum of the judgment. You did not file a paper when you should have filed it. And nobody's talking about the real issue of image rights or the real issue of how to decide distinctiveness of a trademark, which is the main dispute. They leave the dispute and they're talking of technical issues of law because the person knew IP but did not understand technical issues of law, and he failed to trigger one of those technical issues and therefore lost out. So people like me, what I said is that I want to remain in litigation, but to be able to always flag IP issues so that I do not fall, the IP issue does not fall prey to a technical issue, because we do all that should be done technically and ensure that all that the judge is called upon to answer is the IP question in that case, not some technical issue about whether you missed the time for a filing or you did not take permission of the court to file a particular paper and all of that. So I would encourage us, in your journey in IP, please begin to think about what area. Now you have met Amobi now. Like I said, hold on to him. If IP in sports is what you want to do, then hold on to him. Because IP in sports alone would give you a meal ticket for the rest of your life. You don't have to bother and fight in too many things. Just get into that area now and begin to learn. Begin to follow him, follow what is right on social media and all of that. If you want to be a litigator like I am, yes, get and understand the basis of litigation, but always remember to always understand how the IP issues in litigation are triggered and ensure that you are able to carry the IP issues through in a litigation so that the judge is always able to see the IP issue and answer the questions of IP law that arise, not some other technical questions. Of course, there are so many other areas. Pharmaceutical is another huge area. Technology, of course, another area where IP plays a huge part. So find one area of IP law and ensure that in all your learning, you begin to get into that. So today, last example I'll give you. Today, for instance, I went to participate in a retreat of a client's company because they have had issues with a lot of their employees leaving the company, going to set up a competing company against their own, poaching employees from the company, taking their trade secrets away, despite the fact that they have registered some of their designs. A furniture company, they have registered some of their unique designs, but they've had a lot of fights. So we are currently in court on their behalf, trying to enforce what we call the non-compete and non-solicitation clause in the employment agreement of some of their employees who left. So we're trying to train them to help other staff in the company realize the importance of respecting your employer's IP and avoiding these kinds of scenario, and then letting them know what you can do when you leave the employment and what you cannot do, what amounts to misappropriation of trade secret and what do not amount to it, and all of that. So in doing that, what it begins to show us is how this IP really can make a difference for my client. It's not just about knowing the technical rules of trademark and all, but in the real sense now, this is a headache that this businessman is having. It's not allowing him sleep. How can we use IP law to solve his problem? So please always think about IP law from that perspective, not just from the dry position of the law, but how can the IP I register for my client, how can that IP really make a difference in business? If you do that, then you can really reap a lot of benefits from your knowledge of IP law and also help businesses to reposition themselves and actually get into the path of growth and of profitability overall. So it's always a pleasure to meet you guys. You can always reach out to me on WhatsApp. Unlike Amobi, I have a funny habit when it comes to social media. Sometimes for 3 weeks, I won't check my LinkedIn, and then another 3 days, I can spend all the 3 days on the LinkedIn. So I'm very funny when it comes to social media, but then you can always reach me. You can take my number from Juliana. WhatsApp is always the best way to reach me. Send me a message on WhatsApp. I typically respond at least by the end of the business day. So I mean, like I've said, it's good to meet you guys. I mean, anyway, I get to, I believe Peter is from Kenya, right? I mean, Kenya is a country I love a lot, and I hope to be in Kenya soon again. So I'm sure when I get there, I'll get to see him as well. And please feel free to always reach out to me at any point in time. And if you see me in person, it will be a delight to meet you and to shake your hand. So thank you, Juliana, and thank you everyone for inviting me. And of course, thanks Amobi as well. It was great to see you.
Thank you, Max. Max, you told them to follow me. When they come to hold me, they will see that I'm holding you already.
Thank you so much, Mr. Mark. Thank you, Mr. Amobi. Today has been a very interesting class, and I'm so happy that I listened properly from the beginning to the end. I've actually learned a lot, and a big thank you to all the mentees. Thank you for presenting. You people presented beautifully today. Well done. And to the moderator, Mienia Basi. Hope I pronounced your name properly. Thank you so much for presenting for moderating beautifully. And to all the people that presented today, Precious, Benjamin, Robert, Titi Lola, beautiful presentation, beautiful research. Well done, everyone. And to Hussein, thank you for helping with the administrative back end. So to everyone, I want to say that today has been amazing. I trust that you also enjoyed it. From the comment section, I can see people just writing that they enjoyed today's session. Please take a screenshot here or go to the YouTube channel, take a screenshot, write what you learned on LinkedIn or on Twitter, tag the mentors and appreciate them publicly. People like public display of affection. So don't just say that you enjoyed it here secretly. Say it publicly. That's how people like to be loved or like to be appreciated. So please publicize your appreciation for the mentors today. Thank you, everyone. Have an amazing weekend. Please rest and take care of yourselves. Thank you, sir. Thank you, Mr. Amobi. Thank you, Mr. Max. Thank you, Precious. Those of you that
Thank you very, very much. Thank you so much.
Bye-bye.
Bye. Thank you.
Thank you, Hussein. Thank you, everyone. Bye.
Bye, Ma.
Bye.